Hello. I want to welcome you all to the 18th Stead Lecture on International and Comparative Law. This lecture is the high point of our academic year, and I'm very glad to see you here. Before we start, I just want to say, before I introduce our speaker, I want to say one or two things. The first is I see that we're honored to have in our audience Meb Turner, the former president of this university. Thank you very much, Meb, for being here. You honor us with your presence. I also, because I see quite a few students, want to let the students know that tomorrow a representative from the United States Department of State is going to be coming to the university to talk to you about jobs at NGOs and how to get them. And so if you're interested in that sort of work, this would be a good opportunity to get feedback. What time is that going to be? 12:30. 12:30 in the... 12:30 here, so just right around the corner in the right theater. So if you're interested in that kind of work, I think this is a good opportunity, and tell your friends. Our speaker today is Ann Peters. She is the former president of the European Society of International Law, of which I am a loyal member, and known to me for some time as one of the leading scholars of public international law. Something, I don't know whether it really is a field, but international constitutionalism. I think many of us feel that there now is an international constitution. And she wrote a book recently published on the constitutionalization of international law, which is a topic which I think is very important. She is a member, she's a professor at the University of Basel, I perhaps should have said that first, the Dean of Research there, a member of the Council of Europe's Commission on Democracy Through Law, the Venice Commission, and she is, I think, presently at the Wissenschaftskolleg in Berlin. So someone who has a very wide experience in international law and brings us, I hope, a European perspective. I'm expecting her to criticize and contradict everything I've taught you in my lectures. I hope that will happen. Professor Peters will speak for about half an hour, and then she will entertain questions from the audience. So I'm looking forward very much to hearing her remarks, but also to hearing your questions. Professor Peters.
Thank you very much, Professor Sellers, for these kind words of introduction. I feel very privileged and a little bit intimidated to give the 18th Stead Lecture here at this prestigious law school. And I'm aware of the fact that Baltimore has quite a lot of historical ties to Germany, and I myself am based in Basel, but I am a German citizen. And just before I came here, I wanted to take opportunity to visit this city I'm here for the first time, so I went to the Fells Point and also to the Walters Museum, and we saw an exhibition of a local painter, Richard Woodville, and I was surprised to learn that he studied at a German arts academy too in Düsseldorf. So Professor Sellers, he published an important book on Republican principles in international law in 2006, and in that book he pointed out that Kant's transcendental concept of public right requiring publicity captures a central element of Republican justice. Publicity is a traditional term of political theory and of philosophy, and whereas transparency, the topic of my talk today, has become a more recent buzzword. I'm going to speak about transparency in international law, and I am afraid that I will disappoint Professor Sellers in contradicting everything what he says, because I feel that we are on the same wavelength in many respects concerning international law. The buzzword transparency abounds currently in international law. In all major fields like environmental law, economic law, human rights law, international humanitarian law, health law, peace and security law, demands for more transparent institutions and procedures have recently been voiced by civil society actors, by states, and within the international institutions themselves. We might call this a transparency turn in global governance. But first, of course, we have to clarify, what do we mean by transparency in this context? I understand transparency as a culture, condition, scheme, or structure in which relevant information, for example on law and politics, is available. I put that working definition on the handout, which was distributed to you, and I hope that the handout will help you to follow the talk. I think there are more copies available if somebody doesn't have one. So generally speaking, if something is transparent, you can see through it. The opposites of transparency are opaqueness or opacity, secrecy, confidentiality, but also complexity and disorder. You see that the multitude of antonyms shows already that the concept of transparency has various multiple meanings itself, depending on the context. The empirical observation from which I want to start is that, in fact, international institutions, processes, and mechanisms in international law have, on balance, become more transparent in the sense which I just defined. On the handout, I gave you a list of recent documents in that context, and I distinguished, that's on the first and second page, I distinguished between transparency for governance, and by that I mean requirements imposed by international law on states, and on the second page, transparency of global governance, meaning the transparency of international organizations themselves. I mentioned, for example, in historical chronological order, the EU Transparency Regulation of 2001, the Aarhus Convention on Environmental Information, then the new Council of Europe Convention on Access to Official Documents of 2009, and a recent general comment of the UN, of the Human Rights Committee on Article 19 of the CCPR, which is on freedom of speech, including the right to information and including the right of access to official documents, according to that new general comment. Concerning B, the transparency of international institutions, documents standing out are the Sutherland report on the transparency of the WTO. I gave an example for the transparency policies of a recent climate conference. The World Bank has also introduced a policy on access to information in 2010. And the last document I mentioned is a proposal by the S5. I don't know whether you know here what the S5 means. The S5 are the small five, as opposed to the P5, the permanent 5 members of the Security Council. And Switzerland is a member of this S5 group. And they formulated a draft resolution on improving the transparency of the Security Council. But this resolution did not go through in the General Assembly. We might speak about that perhaps in the discussion. So there is clearly a trend of more international transparency. And I think that this can be compared to a prior development in domestic law, namely the so-called freedom of information explosion, which happened since the 1990s in domestic law. An important factor for understanding this new transparency, or the transparency turn of global governance, is, I think, globalization. Globalization and the concomitant global governance expansion and intensification have, in at least 3 regards, created to some extent a novel degree of political intransparency first, and that calls for compensatory transparency measures. I suggest that in order to at least preserve the current level of transparency of governance, modifications are necessary in 3 dimensions. The first dimension is the object of transparency, relating to the question, well, what exactly should be transparent? In the context of international law and global governance, relevant information would seem to entail that information relating to political decisions, procedures, rules, actions, and also concerning the mode of functioning, not only of states, but also of international organizations, should become more transparent. You could distinguish between documentary transparency, decision-making transparency, and operational transparency. In order to bring about meaningful global transparency, the information given by international institutions must be relevant, that must be salient, but of course there will be different opinions on what information is relevant and what's not relevant. The information given should be accurate, and third, it should be practically accessible. It must be physically accessible, available, it must be financially affordable, and it must be intellectually comprehensible to any recipient. Transparency also requires giving reasons for action taken or not taken. With regard to legal acts, this obligation to give reasons is anyway inherent in the rule of law, because it is a precondition for any legal scrutiny of the lawfulness of a legal act. In concrete terms, global transparency may relate to different activities and different documents of international organizations, and a reasonable measurement of global transparency might require that international actors maintain websites, publish their acts, publish their budget, and issue annual activity reports. And a different matter is access to preliminary documents, to drafts, to deliberations, to working documents. There we have some difficulties, and I will come back to that. Through the second dimension in which transparency is being enhanced and should be further enhanced concerns the obligees of transparency. I don't know how to pronounce that word actually. The one who should be transparent. I think that's the obligee. Is that right? The debtor of transparency, the one who owes transparency. And these are, in an international law perspective, not only the states, but of course international organizations like the WTO or the World Bank. And the third dimension of transparency are the beneficiaries, who are the recipients of information. The transparency obligations of states and of international actors should be extended, have been extended, and should be extended to new types of beneficiaries, such as foreign states, other international organizations, and to those natural or legal persons, moral persons, who are not formally under a state's jurisdiction but are substantially affected by policy decisions of a foreign state or of an international organization. Factually speaking, the circle of these beneficiaries of transparency would seem to be expanding already. It is quite obvious to me that a purely interstate transparency relating to the relationships between nation states is increasingly being seen as insufficient. And this development might well evidence a growing perception that the ultimate constituency of international law and politics is human beings, and that these form a nascent global civil society, and this apart from being organized into nation states. I think that we here have a positive feedback loop, because granting more information to the general public in turn helps to constitute such an imagined, maybe only imagined, global civil society. And NGOs, of course, symbolize just such a global civil society, although they do not in any formal sense represent a global citizenry. So to recapitulate the fact and the positive value I ascribe to these developments, to these three extensions of transparency, my normative argument is that the more intense that global governance becomes, the more it takes over functions that were previously fulfilled by domestic actors. Because of the impact and because of the functions of global governance institutions, these should be subject to similar, at least functionally similar, legal constraints and conditions as in national governance. And therefore, the principle of transparency, this is my normative argument, the principle of transparency should also come to bear more on global governance as a constraint and as a condition of governance. And that type of transparency might be called compensatory transparency, because it is intended to compensate for transparency losses, which are, as I said, side effects of globalization and also of privatization, which I did mention before. This compensatory transparency can be understood as a manifestation of global constitutionalism and multi-level governance. So far, so good. But the question is whether international transparency, although it may be desirable or even necessary, as I just argued, especially under the compensatory rationale, it might well be unfeasible. The main problem would seem to be that there are substantive and structural differences between domestic and international law structures. So what are the relevant differences, and do they really prevent the application of the transparency principle? Most importantly, of course, international legal system lacks two core constitutional features. First, it is not a product of direct democratic procedures. Second, the international institutions possess neither a system of checks and balances nor a separation of powers. But these important constitutional differences do not as such prevent the transferability of transparency requirements to the international realm. To the contrary, it encourages it. As Nobel Prize winner Joseph Stiglitz has pointed out, I quote Stiglitz, "The less directly accountable a governmental agency is to the public, the more important it is that its actions be open and transparent." End of quote, Stiglitz. The blurring of the line between domestic and foreign affairs has itself undermined the possibility of neatly and reasonably distinguishing a sphere of domestic law and politics, which must be transparent, from an international sphere in which transparency seems neither feasible nor warranted. Without attempting to downplay the differences between domestic and international law and governance, it seems fair to say that national and international transparency systems nowadays represent variations of one single governance theme. I now skip one point on the handout, which I labeled transparency as a power shifter, and immediately turn to point 5 on the handout. What are the value and functions of international transparency? The commitment to transparency of the international organizations manifests a normative conviction, and voluntary transparency sends a political signal about these. In international law and governance, I think there are 3 core clusters of functions of transparency. The first cluster is accountability, participation, and democracy. The second cluster of functions is transparency as a part of good governance. And the third cluster of functions is effectiveness and efficiency. I will now only speak about the first cluster, accountability, participation, and democracy. Democracy needs transparency, and the classic statement in this regard was tendered by James Madison. I quote Madison, "A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both. Knowledge will forever govern ignorance, and the people who mean to be their own governors must arm themselves with the power which knowledge gives." End of quote, Madison. Transparency is, in other words, obviously a conditio sine qua non, a necessary condition for the informed consent of the governed. It is critical for uncovering abuses and for defending interests. Transparency facilitates control and scrutiny. Under that perspective, transparency is important because it can arguably alleviate the famous democratic deficit of global governance. But transparency in itself does not bring about democracy. It is only a precondition for democratic procedures. Transparency can help to improve accountability. But one question is, to whom the accountability of international law and policymakers, notably the international organizations, should extend? Only to the member states of specific organizations, or to all states, or even to a global citizenry? In this context, the political scientists and philosophers Alan Buchanan and Robert Keohane usefully distinguish between narrow and broad accountability. Broad accountability means not only allowing those who presently receive the accounts, that is the states, notably the member states of a specific organization, but others, such as NGOs and populations, could contest the very terms of accountability. The gist is that broad transparency is needed for a critical revision of the terms of accountability. The broader constituencies, NGOs, people, humans, should be enabled in order to obtain the capacity for revising the terms of accountability, and that requires broad transparency. Institutions must facilitate positive information externalities to permit an inclusive, informed contestation of their current terms of accountability, Wright, Buchanan, and Keown. And seen in that way, transparency becomes even more important for accountability because it can address the current accountability mismatch of global governance. But here comes the objection. Is not transparency merely a surrogate, an ersatz, replacing the much more difficult substantive issues of democracy, of good governance, of economic efficiency, social justice, and the rule of law? This objection, I think, is well taken. There does exist the danger that certain types of transparency will degenerate to empty titles of legitimacy. Indeed, the transparency discourse is ambivalent, and the use of the concept of transparency ranges from good faith to cynicism and hypocrisy. More importantly, the debate on transparency not only masks other issues behind itself, but also reconfigures the reality of global governance. The gist is that transparency is indeed a substitute, a proxy, but a necessary one, I think, because it replaces in a global and pluralistic political space the unattainable certitude and conviction about the right and just international law and policy through a procedural device allowing everyone to form their own opinion on matters of global governance. If accompanied by mechanisms of participation, transparency helps to shape and revise those matters of global governance through a public debate. To conclude, while transparency policies to a certain degree generate only an ersatz legitimacy, a substitute legitimacy, and may even at times be counterproductive, they more often seem a reasonable initial step towards improving the accountability and legitimacy of international law and governance. But still, transparency has its drawbacks. Analytically speaking, we can first of all distinguish between the intrinsically negative effects of transparency, notably the dangers posed to the quality of deliberations. And on the other hand, we have countervailing legitimate interests such as security, privacy, and business or trade secrets. Secondly, as it is the case with basically all policies, transparency measures have of course their financial costs and may be unfeasible due to time constraints and space constraints. Thirdly, there is the danger that transparency may only be simulated through data flooding, drowning in disclosure, disinformation, and propaganda, something which has traditionally played an important role in international relations. An important point is that transparency measures can be circumvented. The legal and political actors might hold conclave behind the facade of a public meeting. They might keep secret files apart from those that are public, or minimize record keeping altogether. If such are the foreseeable or inevitable consequences of transparency or of too much transparency in a certain context, in the end, the entire policy will be rendered ineffective or even counterproductive, and thus creating yet more intransparency. The most serious drawback relates to the deliberations, and that's the next point on my handout, to deliberations and to democracy. The traditional ethos of democracy is, of course, as you know, confidentiality. A British diplomat wrote still in the 1960s, I quote, "The old principle that the art of negotiation depends on reliability and confidence is an eternal principle," end of quote. But the more the processes of international law move away from the purely diplomatic mode, the more they lend themselves to publicity. And this applies both to lawmaking, but also to the settlement of disputes. A recent example of a commitment to transparent diplomacy are the climate negotiations. The conference and meeting of the parties of the UN Climate Convention and of the Kyoto Protocol held in Cancun in 2010 was explicitly conducted under the heading of transparency. This was in line with the pertinent UN FCC guidelines, but was also specifically highlighted by the Mexican hosts. They gave a full commitment to the principles of transparency and inclusiveness. This did not damage the negotiations. The outcomes of the conference were not particularly good, but this was not particularly due to the more transparent conduct of the conference. Maybe with less inclusive and less transparent procedures, it might have been even worse. So what's at stake when making diplomatic negotiations more transparent, contrary to the tradition? The negative effects of transparency have been highlighted, for example, by the political scientist and lawyer Hans Morgenthau, who warned against the vice of publicity in diplomatic negotiations. I quote Morgenthau, "It takes only common sense derived from daily experience to realize that it is impossible to negotiate in public on anything in which parties other than the negotiators are interested," writes Morgenthau. So what exactly are these negative, commonsensical negative effects of allowing non-participants to listen to negotiations and other types of deliberations? The negative effects can be summarized as follows. The participants tend to become, under public scrutiny, more inflexible, more radical, or they lose candor. They become maybe adverse to risky and innovative opinions. Transparency tempts the participants to rigidity and also to posturing, increases the chances of a stalemate in which no compromise is possible, or alternative, a short-circuited and hasty agreement. To pull back from a bargaining position, often done solely for strategic purposes, might be interpreted, if done in full view of the public, as giving in to the opponent. The public gaze tempts deliberators to bypass creative or still tentative ideas and leads to a premature closure. In sum, the chances for collective learning are diminished. That's the claim of that's the summary of the dangers of transparent negotiations. On the other hand, publicity or transparency of negotiations might also have some positive effects. And the main positive effect or beneficial effect of a public audience for deliberations is what John Elster has called the civilizing force of hypocrisy. Transparency might force the lawmakers and the decision makers or the negotiators to explain their positions with reference to socially acknowledged norms. Social pressure will cause them to base their statements on claims of general interest rather than on selfish appeals. These may be hypocritical, but even if hypocritical, these statements may still generate better outcomes because the bad arguments are officially banned and therefore have much less power to influence the decision that is ultimately reached. Because of these both negative and positive effects of transparency on different forms of deliberations and negotiations, the problem for any institutional designer is to properly mix transparent and intransparent elements of deliberations and to adequately circumscribe the zones and phases of intransparency. Importantly, I think the granting of exemptions from transparency to protect deliberations must be based on systematic research into this matter, empirical research, which has also already been done by political scientists. I don't want to go in detail here. Based on such research, institutional designers could, for example, link the allowance or any allowance to deliberate behind closed doors to reproducing the pluralism of the public in private by admitting certain stakeholders to these pre-deliberations behind closed doors. Another idea is to allow participants to conduct pre-decisional discussions and deliberations in private, so long as the members of the body later publicly cite the reasons for their individual decisions and votes. These would be two examples for how to combine transparency and intransparency. To sum up, transparency in deliberations always implies a trade-off and requires a clever design. I now come to point 8, which is what interests international lawyers, of course, is what is the normative quality of the transparency principle, which I've here been advocating in a way. Is it already a principle of customary law? Is it a general principle of law? In any case, there is no general international transparency treaty or so. But in order to be legalizable, under these headings of customary law, general principle of law, a concept must at least meet two fundamental structural preconditions. It must be sufficiently precise to generate an obligation and to assess its implementation, and it must have a debtor and a creditor. And both conditions are not easily definable or fulfillable with regard to the transparency concept. As a result, I think it's difficult now to argue that transparency is already a normal part of international law, and maybe it can never become a hard norm law because of the lack of precision and the lack of the clear debtor and creditor. But this finding might be of little relevance. Maybe the classic boxes, the sources of Article 38 ICJ statute do not tell us much about the state of international law and its power to influence the behavior of internationally relevant actors. One possible catalyst for the consolidation of the transparency norm in the direction of hard law is the human right to information, which is a positive human right laid down in all universal and regional human rights conventions. And this right to information has recently been interpreted by various regional human rights courts, by the Inter-American Court and by the European Court, to encompass a positive right to have access to official documents. That's an extension, a quite recent extension of the right to information, an important extension in our context. But, of course, as you know, the human rights covenants are, under the law as it stands, only opposable to the member states of those conventions. But, in order to function effectively as a vehicle for global transparency, the human right to information would have to be opposable to other actors than only to states. Because, as I argued before, the international organization's relative gain in competencies and powers, relevant and important information is increasingly held by those organizations, not only by states. So, as not to diminish the value and function of the human right to information, it would have to be extended to these new information holders. For example, a right to information might be usefully claimed so as to counter World Bank decisions to finance ecologically sensitive development projects. You would need information for that, about it, to challenge them. The Human Rights Committee's general comment on Article 19 CCPR, which I quoted in my list on the handout, is in fact along these lines. The comment gives a functional as opposed to a formalist account of the debtor of the right to information by saying, I quote the general comment, Article 19 embraces the right of access to information held by public bodies and may also include other entities when such entities are carrying out public functions. This, what the committee had in mind was privatized organizations carrying out public functions, but you could also say that international organizations also carry out public functions. So it is, with a little bit of creativity, possible to interpret that comment as espousing a right also against international organizations. To conclude, the international human right to information, if interpreted extensively, could function as a vehicle for more global transparency. So in the end now, I would like to formulate some policy recommendations. De lege ferenda. International law and institutions should be rendered more transparency. That is, the current trend, which is clearly visible, should be basically continued and reinforced. However, because of the mixed effects of transparency, which I explained a little bit in detail concerning deliberations, any move in this direction must be qualified. So the question is not so much whether transparency should be created, but rather how much transparency and when, at what point in time. Total transparency of international law and processes is neither appropriate nor realistic. Those presiding over international law and other policymakers should treat transparency as a variable of institutional and legal design. They need to balance the potential negative effects against the positive ones. Importantly, I think, and that's a proposal now, legal presumption of transparency should be acknowledged. A legal presumption. What concrete consequences would such a legal presumption engender? A presumption of transparency means that the non-release of documents and the closure of meetings to the public must be specifically justified on the basis of legal exceptions which have been clearly defined and circumscribed prior to the fact. These exceptions can only be granted by stating the reasons for them publicly, and the burden of explaining and of proving the need for secrecy is thereby placed on the institution itself, not on those outsiders who request access. The legal presumption of transparency furthermore generates the obligation to keep the degree of intransparency as low as possible. Intransparency is also rendered the more acceptable the more it is embedded in what we have called meta-transparency. Meta-transparency means that the reasons for the intransparency, for example, whether it is necessary at all, and its substantive and temporal scope, must themselves be made transparent. In other words, the question as to whether, how much, and for how long intransparency is warranted, for example, the need for a closed-door debate, the circumscription of exceptions, possible reform of the policy, all this must be subject to a public debate, and it is thereby that an element of public accountability for the secrecy itself is introduced. In the end, only such a meta-transparency provides the necessary means for transcending the limits of transparency. My conclusion is twofold. First, national and international transparency today constitute a form of multi-level transparency, which is not simply the result of adding national and international transparency, but which in itself has a new quality, the quality of global transparency. Secondly, the rise of transparency might manifest a paradigm shift, namely international law's shift from a private to a public character. Traditional international law, being mainly interstate law, has long been conceived as private law writ large. Hirsch-Lauterpacht famously stated that formally international public law belongs to the genus private law, wrote Lauterpacht in the 1920s. And the public law, private law distinction has some analytic and normative value for international law, because that distinction between public law and private law reflects, but I don't know whether you all agree, reflects the difference between justitia distributiva, to be realized through distributive polities, and justitia compensativa, compensating justice, as realized in the private sphere and through the market exchange. The emerging transparency norm within international law, with its quality as an enabler and to some extent proxy for accountability, participation, and global democracy, is currently strengthening the element of global distributive justice in international law. And international law has in that first sense been rendered more like public law. Second, parallel to this, one strand of political science and international relations research has undergone a deliberative turn. It claims that arguing, meaning communicative behavior on the basis of evolving preferences in which arguments are given and which seeks to reach a reasoned consensus, is not only an epiphenomenon of power and interest, but is constitutive of international relations in its own right. That's the deliberate turn in political relations. And in that literature, arguing, as just defined, is contrasted with bargaining, understood as communicative behavior on the basis of fixed preferences in which demands and threats and promises are exchanged. So the dichotomy is between deliberation, arguing, and bargaining. And the gist is that arguing can be distinguished from bargaining through its triadic nature. Well, that's important for transparency. Arguing, in that sense, involves reference to a mutually accepted external authority so as to validate empirical or normative assertions. And that external authority might be an audience which serves as adjudicator of the better argument. And that audience might be the public observing the negotiations, for example. And it is within that paradigm that transparency would appear to be an indispensable element of global governance. Ultimately, with the structural change towards presumptive transparency, which I mentioned, international law is becoming Public in various senses. A law which constrains public authority, which seeks to reconcile global political authority with individual autonomy. A law which is in the global public interest, so to speak, for the public. A law which is made under scrutiny of the public, so to speak, through the public, even if it is not fully made by a global public. The transparency of governance is only a necessary and not a sufficient condition for bringing about participation, accountability, and possibly democracy in the global sphere. Moreover, there is no automatic progress from global transparency to proto-democratic forms of self-determination of a global citizenry. We might rightfully reclaim global transparency, but we also have a responsibility to act, to strive in transparent debates and processes through deliberation and contestation towards a just international legal order. Thank you.
Thank you, Professor Peters. It was very lucid and persuasive remarks, and I'm reminded again how often I seem to agree with what she says and writes. I did again today. Professor Peters has very kindly agreed to take questions from the audience for some period of time, and therefore I call on you for questions.
I was wondering about the case that you have in your outline, Gilbert v. Sweden. I'm assuming Gilbert sued Sweden because he didn't have access
to some official documents.
So what kind of damages would he? I don't know what happened.
Okay, I don't know either whether and what damages he was awarded. You know that the European Court normally, finds it has found a violation by the state, so the obligation is to undo the violation. So normally the state would have to grant access then to the documents. Plus, if the violation cannot be completely remedied, then the court can award just satisfaction. But that's normally a very low sum. I really don't know what was awarded in that case. But you can easily find it through Hudok. Yeah.
Yes, I'm Henry Jones, alumni criminal justice, class 93. The last time I heard someone use that word transparency was Hillary Rodham Clinton. And she was making a speech in front of an audience I couldn't really label right now. But I'm wondering if you were aware that she was calling for a policy of transparency in the international community.
Oh no, I wasn't aware, but of course I find this very positive. Yeah, maybe I could ask you at a later point in time which speech that was. Clearly, maybe to add to your remark, the United States were, after Sweden, one of the first countries to establish freedom of information regulation already in the 1960s. But there was a real worldwide boom only after 1990 on the domestic level. And my argument of the talk was that somehow this has apparently spilled over to the international institutions themselves. Also in reaction to criticism, of course, World Bank and WTO.
That's the reason.
I'm interested in the source of this transparency, where particularly your notions of whether a treaty, whether it be part of much broader based international law. Notwithstanding the words of Madison that you quoted, our Supreme Court refused to locate transparency in our Constitution or in the First Amendment and left it to statutory law, public meetings laws, Freedom of Information Act at the state and federal level. And the exceptions, the justifications for intransparency, as you called it, have come to, in many cases, swallow up the notion of
Yeah.
freedom of information. How do you prevent that from occurring
Yeah.
at an
Okay.
international level?
Yeah. Okay, these are of course very important points. As I said, it is necessary to have exemptions because total transparency would be counterproductive and bad. But I said, and the main exceptions on the domestic level and also potentially on the international level is first relating to privacy, including business, private secrecy on the one hand, and very important national security, and also not only military security but all kinds of security issues. But the tendency of officials, office holders, committee members, lawmakers is always to overstate their case. So I propose two legal strategies. First, the legal presumption in favor of transparency, which puts the onus of justification on the ones who want to keep everything secret. So this shifts the burden of stating and of justifying on them, which is already a little help for those who seek information. So the first is the legal presumption, and the second is this what I call meta-transparency, that it must always be possible to discuss the exemptions in public. Only then you will be able to transcend the secrecy, and only then you can counteract the risk that the rule is swallowed up by the exceptions, as you aptly put it. I think that the same issue, for example, in WTO dispute settlement, you have very often the problems of business secret, because these are, of course, WTO is only interstate disputes, but what's behind the states are, of course, business who also do the lawyering and so on. And they claim that they need, all the documents must be secret. But the WTO dispute settlement bodies, the panels and appellate body, have already issued decisions circumscribing these, trying to limit these claims for business secrecy in the WTO.
Mr. Weber.
Actually, I think you just answered my question. It wasn't the exact question I was going to ask, but the answer was.
Okay, I'm happy about that.
Well, I was going to ask what level of transparency you foresee or what you want in the United Nations Security Council.
Aha, okay. Well, we didn't speak about the UN Security Council, and I'm happy to expand a little bit on that because, as I said, there was the initiative by the S5. The S5 are five small states, Costa Rica, Switzerland, Liechtenstein, Yemen, and Jordan, I think. And they, knowing that a formal charter revision abolishing the veto or so is impossible because this would require a positive vote of the P5 themselves, so this is unfeasible. They proposed improvement of the working methods because nowadays at the P5 they meet they're not called green rooms like in the WTO, but they meet somewhere in secret, and there is no there are no real policies of the Security Council to prevent that. So they tried to bring the General Assembly to vote on a resolution obligating the Security Council members, especially the P5, to give reasons for a veto, for example. Not outruling the veto, that's unfeasible, but just to explain it. And if we take, for example, Syria now, Russia, if it has to give an official explanation, would not be able to say, I veto this because I want to continue with my arms trade. They would have to make up a different reason. I mean, they could not veto something to say, oh, I like the genocide and crimes against humanity going on. And then you could say, oh, well, they can make up anything, and that's the hypocrisy. But then comes the claim by Jon Elster, which he also studied empirically by comparing also deliberations on the French Constitution and the American Constitutional Convention, saying that even this hypocrisy has a civilizing effect. But the, I think, very good proposal of the P5, of the S5, was turned down. It was not allowed to be voted on because the legal advisor, the legal service of the Security Council, issued a memorandum saying that this reform would have implications of charter amendment, would have an amending effect, and was therefore not allowed without a formal amendment. And I think this is not good lawyering, because it was specifically designed so as not to require an amendment. It could have been done on the level of rules of procedure. the S5 were very disappointed. They withdrew the proposal before it came to a vote.
I realize we've been mostly talking about like interstate international law, but and how to have transparency there. But what could international lawyers do to encourage transparency at a local level in countries where maybe there's not that tradition or tradition of democracy?
Okay. Well, of course, I was speaking now about international law, but I also said that we have a multi-level system nowadays with international, regional, national, and maybe also subnational, and in a way it must work together because, of course, also the local institutions are the one which actually have to implement international law, which is also good on the principle of subsidiarity. It's better. They know more about what's really going on the ground and so on. That's how the whole international system is set up. So in a way, you ask now what can be done for those national institutions or local institutions when they apply international law or when they apply their own domestic law. I mean, these are two different things which should go in hand, but which are still two different issues. And when they apply a national law, then they're of course subject to their domestic laws. And as I said, there has been maybe I don't know the exact figure now, more than 50 or 60% of all states of the world have freedom of information laws, what do you call your law, acts, government in the sunshine law, and so on. So, I mean, I can't make any recommendation for any particular country now, but there is a lot of also NGO activism going in that direction. And I can see a clear tendency of the courts, which I mentioned, the European Court of Human Rights and even earlier the Inter-American Court of Human Rights and the Council of Europe forcing governments to enact such laws and to implement such laws. And that is, for example, the Council of Europe Convention on Access to Information, meaning that those states of the Council of Europe who ratify that convention must enact appropriate laws and must also implement them. And how they do that is, for example, spelled out in that convention, which is, however, not yet in force. And the motives of that convention are, as they are mentioned in the preamble, are exactly the ones which I told you as clusters: democracy, participation, accountability, effectiveness also, and generally better governance. So these rationales, I think, apply to all levels of government. Therefore, it's important to see it all together. Not mix up, but how it takes place. Yeah.
We have time for two more questions. And
I was wondering, the explosion of transparency that has happened in the last 25 years, and now an effort to perhaps standardize and create a schema for transparency. Right. Do you think that is a proactive, something being proactively done more so, or is it reactive based on advances in technology and just the inability to keep people from information?
Yeah, that's an excellent question which I can't answer, and I think it's probably both. Of course, it's multifactorial. First of all, it certainly has to do with the, let's put, fall of the socialist bloc. That's the states of the East, communist states, that they have been working towards capitalism, you could say, liberal states and so on, and that therefore their ideological outlook also changed. Secondly, it's a function of information techniques which makes the information, the granting of information also much cheaper and easier. For example, there is now a tendency, even in those states who had transparency or freedom of information laws before, to a change from passive to active transparency, in the sense that everything is put on the web, which makes it also cheaper for the agencies themselves, because they don't have to do any work if everything is accessible. And there is even another movement now which is ongoing, is the access to so-called raw data, meaning that in order to, there is the reproach that if the authorities, domestic or international, put information on the web, it's only how they want to present themselves. It's how they view the world and how they want to be seen. So the request now by civil society is that they want to have the raw data in order to form their own picture. But this is, of course, difficult. Only very experienced and specialized entities or persons can do that. The ordinary citizen won't be able to do anything with the raw data. So different new types of stakeholders are being empowered by these polities. In former times, it was important to know somebody in Congress or what to be able to phone him and so on and to ask something. And now this information is open, so those who have the skills to transform the information and know what it's really about, they are more empowered than others who just look on the website and don't understand much of it. So the political, technical, and also in a reaction to legitimacy crisis and reproaches, scandals of corruption and so on all the public and private sphere.
Our final question, Dean Weiss.
I think my question actually follows on the discussion of the impact of technology on the transparency movement. And you acknowledge the limits of transparency. Certain people would say that official deliberations should be transparent. Memorializations of decisions should be available to the public, but you acknowledge that there are deliberative conversations that should not be because they chill the deliberation.
Exactly. Yeah.
Today, however, so much communication is electronic and therefore can be memorialized. That is to say, you can print out an email.
Yeah.
Or it's easy to transcribe phone conversations and voicemail messages, for example. So simple deliberations that previously would have happened at a restaurant between diplomats, for example, now might occur in a back and forth email chain.
Yeah, but
and
I
yet
think,
suddenly, you could say, well, let's put that on the web.
Yeah, but I think people who are careful, I mean, probably you also experienced that at your university. I mean, if you want to talk something really important, you're not going to write an email. You just write in the email, can I phone you at what time?
But instead of discouraging email communications, why not exempt more informal methods of electronic communications so that people can
okay, that would be another proposal. As I said, I mean, we're there. You have to find a mix, and you have to experiment maybe also. And it's clear that total transparency would backfire, and the negative effects would overweigh the beneficial ones.
Well, I want to thank you very much. I have two small gifts. One from myself and one from the university. You may have noticed that some of the people here are wearing this uniform, which are the colors of the Center for International and Comparative Law. If you go to the International Court of Justice wearing one of these, they take you through the front door and sit you in front. So we're giving you our scarf, which I think you can see some people wearing.
Wow, this is excellent.
This
I
is
think
the
it
colors
fits
of the
exactly.
center.
I'm going to wear it right now.
So that's the gift from the university. And then often when I travel, at least, as you were traveling, I find it's difficult sometimes to get to sleep in a strange setting. And so I'm giving you a book that I've written.
But I don't own a personal copy, so I'm very happy and I will ask you to sign it, but you already did that. I also have something for you, but it's not food for thought. So this is from Switzerland.
Oh, wonderful. The Leckerli House. Thank you very much. And speaking of food, you're all invited to a reception, and we have, if you want to ask our speaker more informal questions, there'll be an opportunity, and also just to talk with one another. So thank you for coming, and I invite you to the reception.
Symbolizing the effect of that prophecy.
Yeah, that's good.
We're showing
They got a nice titter in there.
That's my notes, yeah.
Yeah, I'll program it.
Thank you very much for coming.
How is it?
I'll be in that library.
So I don't want to discourage people.
No. I'll be back.
There's that's right.
Yes, just around the corner.
Actually, you should do it. Yeah. It should be part of this graduate. Yeah. This is I saw her in United States. She wasn't right.
I know you won't be forever. You know, I've seen this already for a long time. You go away. If you have good luck with one other.